Grayson. And they're calling it day 6, but we would count it as day 4. Get that going down here. So let's see what happened in day 7 of the Sean Grayson trial. So this is for the murder of Sonya Massey in July of 2024. Day 7 is going to include closing statements from the state and the defense. Jury deliberation scheduled. We know now that that's currently underway. We've entered the courtroom. Judge Cadigan has also entered. Grayson wears a dark suit with the black and gray pattern tie he wore last week. They are noticing every detail. I remember he already wore the tie. Judge Cadigan goes over jury instructions with the attorneys. We have finished going through the jury instructions. And I don't think they say it here, but remember we heard when we were reading yesterday, the jury instructions will include a lesser of second-degree murder. So Judge Cadigan says if the jury wants to review the video again, they would have to return to the courtroom and watch it in silence. So exhibits aren't going back with the jury. Closing statements will begin at 9 a.m. Donna Massey, Sonya Massey's mother, was escorted out of the courtroom by family in tears during the break. She's now re-entered, still crying. Milhiser, the Sangamon County State's attorney, walked into the gallery to hug her. Ben Crump, a civil rights attorney, is entering the courtroom. He greets the Massey family and takes a seat with them. Judge Cadigan has re-entered the courtroom. He says good morning to Sean Grayson. The jury has entered the courtroom. Mary Beth Rogers, assistant state's attorney, is presenting the closing argument on behalf of the people. Quote, "I'm sorry," Rogers exclaims with her hands up. A gun appears on the monitor. Rogers says, "Those are the last words Sonya Massey spoke." Rogers knocks on the podium 3 times to demonstrate how Grayson treated Sonya Massey when he knocked on her door. Photos of Sonya Massey's driver's license at the scene are shown on the monitor. Rogers, quote, "The defendant knew how to slow things down, but he didn't. He knew how to treat her with kindness and respect, but he didn't, because the defendant didn't care." The monitor shows a photo of Grayson and Massey standing outside her home. Rogers emphasizes that Grayson was much larger than Massey and most likely had to stoop down to get into her house. Rogers, quote, "He wants you to believe that he was scared, but you don't have to believe that because it's not true." Rogers says Grayson continued to lie over and over again on the stand, including when he said he attempted to turn his body camera on after seeing Massey's car. Rogers, quote, "She, Sonya Massey, wasn't threatening him. She was complying." We see a photo of Massey on the monitor with her hands up. Rogers, quote, "For the first time ever, the defendant wants you to believe that he was going to arrest Sonya." Rogers, "The biggest lie he, Grayson, has been telling is that there was nothing he could do. He had no choice." Rogers talked about how the defense got 2 paid witnesses who had eerily similar testimonies. So remember, we had 3 expert testimonies on experts testify about use of force. 1 was called by the state and 2 were called by the defense. I thought those were interesting to read through. So if you're interested in self-defense cases, again, we can only read this. We're not getting footage from inside the courtroom. But I thought ABC 20's coverage through these tweets was very thorough and a great look at the questioning for all 3 of those witnesses. Rogers talked about how the defense got 2 paid witnesses who had eerily similar testimonies. Rogers emphasizes the definition of the totality of circumstances to the jury. Rogers provides an example of officer-created jeopardy. Rogers says that Sonya Massey was not the initial aggressor. He, Grayson, has no right to follow her and shoot her. Rogers goes over the 3 propositions the jury will have to agree upon to convict Sean Grayson of first-degree murder, right? So again, there is a lesser included of second. Rogers goes over the second-degree murder charge, saying that Grayson made a promise to shoot and kill Sonya Massey. Rogers, "When you threaten to shoot someone in the face, and you do, that's first-degree murder." Rogers is done with the people's closing statements. Daniel Foltz, Grayson's defense attorney, begins the defense's closing statements. And let's see. So 1027 to 10:04 is when these are being typed out. That's the about time frame. And we were here. Or actually, let me go back to the thread. That's easier to read that way. All right, so defense begins. Foltz, defense attorney, reiterates to the jury that what happened to Sonya Massey was a tragedy but not a crime. Foltz, quote, "The thing you cannot do is let your emotions dictate the outcome of this case." Foltz emphasizes that the question the jury must answer is whether Sean Grayson was legally justified in shooting Sonya Massey under Illinois law. Foltz explains that every witness who has testified has been paid, citing what Rogers said in the state's closing statement. So that third witness, the first being called by the state, was also paid. Foltz says he doesn't care if the jury doesn't like Sean Grayson as a person, and that isn't what they're here to decide. Sean Grayson watches Foltz while he delivers the defense's closing statement. He leans forward in his seat. Foltz says that it is almost inexcusable that all the evidence wasn't gathered at the scene the first time around, referencing the pot Sonya Massey was using and the third bullet casing. Foltz also references Deputy Farley, who was almost through his 1-year probation period for being a relatively new deputy with the sheriff's department. Foltz emphasizes that Deputy Farley could have been fired for virtually anything while being on probation. And if you're following along with this and you haven't been following the previous day's updates, Farley, he ends up testifying, and it was compelling testimony, I would imagine, to the jury that he didn't think Sonya Massey was a threat in that moment. So he's the only living person that was in that room when the shooting occurred. And he's saying he didn't think the decedent was a threat, was posing a threat, had the opportunity to cause serious bodily harm to the defendant in this case, or himself. And then defense here is pointing out he was on probation, hinting, you could draw the inference, making the argument that if he said otherwise, maybe it could have looked bad for him. He wanted to keep his toes squeaky clean. Foltz says Deputy Farley lied in his updated report to ISP, that's Illinois State Police, because he didn't want to be criminally convicted. Foltz mentions that Dr. Patterson, the forensic pathologist who performed Sonya Massey's autopsy, said that Massey's injuries would have been survivable. Foltz says Dr. Patterson hasn't had a live patient in many years, so he's not qualified to speak on that. Foltz said that Stoughton second-guessed every single decision Grayson made that night, while never having stood in Grayson's shoes before. Stoughton was the expert called by the state. Fulton says Sean Grayson was completely calm when he spoke with Sonya Massey before he heard the pot on the stove. Foltz says Grayson only started to show concern when Massey went into the kitchen to grab the pot. Foltz says that when Massey said, quote, "I rebuke you in the name of Jesus," Grayson believed that was a threat. Foltz says the jury doesn't have to agree with Grayson, but that's what he believed. Foltz says Massey escalated the situation. Foltz: "As hard as that is to hear and accept, the outcome of this particular case was driven by Sonya Massey's actions." Foltz references Corbett and Davis's reports, which both concluded that Grayson's use of force was warranted. Foltz to the jury: "You told us you would judge this man, Grayson, solely on the evidence and the law presented to you. We don't guess whether someone is guilty of a criminal offense. We don't guess our way into a guilty verdict." Foltz has ended the defense's closing statement. We're taking a short break until 10:40. So this is timestamped at 11:19, and they started wherever we left off previously. So it seems like this was a little bit longer than the state's opening. The state gets a rebuttal. Judge Cadigan and the jury have re-entered the courtroom. Millhiser is presenting the rebuttal. Millhiser emphasizes that the defense told the jury not to let emotions dictate the outcome. Millhiser: "That's what happened. The defendant let his emotions dictate the outcome of what happened in Sonya Massey's kitchen." Millhiser breaks down that Kevin Davis's report only referenced Massey's actions and her, quote, "attack." Millhiser tells the jury that this is a murder case and encourages them to trust what they see and hear in the video. Which it seems like they're requesting to see some footage. I don't know if it's like the footage from the moment, but they're having issues playing that for the jury. I guess we're going to look for an update on the current jury question once we're done reading and catching up on these closing arguments. Millhiser says there's nowhere in the law that says you cannot reference the defendant's actions before and after the moment of the shooting. Millhiser: "This isn't second-degree murder, this is first-degree murder." Deputy Farley's body cam footage is played on the monitor. The video occasionally has captions that clarify what Massey and Grayson are saying. Malachi Massey, Sonya's son, has walked out of the courtroom. Members of Sonya Massey's family leave the courtroom. Multiple members of Sonya Massey's family have started to cry. Sean Grayson is leaning forward over the table, not watching the monitor. One juror cries as she watches the footage. She holds her notepad up to her face to hide behind it. This could be reading tea leaves, but I don't think that that's good. I don't think that that's good for the defense. I don't think that's good. Millhiser holds up the pot Massey held to the jury. Here's this giant, dangerous pot. Grayson appears in discomfort. Millhiser quotes when Grayson says he's not, quote, wasting his med kit. Millhiser wonders what's so important in the med kit that Grayson didn't want to waste. Millhiser opens the med kit and begins going through it in front of the jury. Grayson's body cam footage now plays on the monitor. Millhiser, these are the actions of a bully. Millhiser grabs Grayson's gun and the pot to show to the jury. Millhiser, the defendant is guilty of first-degree murder. The people have finished the rebuttal. That was around 12:16, but they took a break, so it seems like that might have been longer if they were playing the footage. Judge Cadigan tells the jury that they can find Sean Grayson guilty of first-degree murder, not guilty of first-degree murder, or guilty of second-degree murder. Or also not guilty of second. I hope that's not how it read in court. Like, I think this might come down to their reporting, right? They're trying to fit it into a post. They can find them guilty or not guilty. And if they don't find you guilty of first-degree murder, then you deliberate. You can consider second-degree murder. And maybe they're not translating that correctly. But let's read this again. This is how it's written. The judge tells the jury that they can find Grayson guilty of first-degree murder, not guilty of first-degree murder, or guilty of second-degree murder. I'm going to hope that this is just getting lost in translation here and that the judge didn't instruct this way. Jurors number 14 and 15, the alternate jurors, have been excused at this time. Bailiffs have been sworn in to ensure no one speaks to the jury. And then the court's in recess. That was 5 hours ago at 12:39 my time, right? This is all in Eastern time as we're reading this. I think Illinois is an hour behind me. So this would be 11:39 a.m. local time. But for the sake of the math, it's 12:39 they went my time here. And then they came back for this jury question at 5:06. Potentially they had a lunch. So they've actually been deliberating like 3-ish hours and change if they took a lunch break. And this is where a few minutes ago we saw this update that Judge Cadigan goes over the evidence the jury asked to review, including Grayson and Deputy Farley's body cam footage. Some of the items the jury asked to see weren't admitted into evidence. Oops. We are taking a short break for the attorneys to go over some logistics. Families are chatting. Judge Cadigan has re-entered the courtroom. The state and defense are deliberating on 2 jury instructions. The state wants to withdraw one of them, while the defense wants to send a note back to the jury to clarify the distinction between the 2 instructions. Judge Cadigan has left the courtroom to look up case law. And now Cadigan re-enters, and I think that's where we are, but we'll refresh in a couple minutes before we end to see what they do. I think it's 4:44 local time over there. So yeah. I think, so guys, I'm going to clip this separately. So I'm going to qualify this for anyone that's listening to that clip. We've been watching the Florida versus Alicia Andrews trial all week. We just got done watching whatever happened today. And at the end of the day, there's an argument outside the presence of the jury where the state wants to play the interrogation of the defendant, but they want to leave out parts where the interviewer, Juan Ramos, and the partner he did the interview with are saying things to the effect of, you could be going away for life. You're facing life. You could go away. You're doing time, like hinting at all of these serious things. And they don't want the jury to hear that because the jury isn't supposed to consider like sympathy and the potential penalties as far as determining whether or not someone's actually guilt, if the guilt is proven by the state beyond a reasonable doubt. The defense is arguing, rule of completeness. It's important for the context of why Alicia might answer the way she's answering in that moment. And I think it's interesting to see the arguments kind of from the opposite position over here while we're going through these closing arguments. Don't think of the emotions. And you have the prosecution argue that this officer should be found guilty because he acted emotionally in the moment, used the emotions in the moment against the defendant. So you can never get away. I don't think you can ever remove yourself from the context, the contemporaneous context, the state of mind in that moment when you're considering why a defendant was acting the way they were acting, and then asking the important question, were those actions justifiable or not? So let's see what you guys are saying, and then we can refresh this and see if we get an update. I wonder if the judge would ask something like, do you guys think you're close or would need more time? Do you guys want to go home? If the court allows jurors to stay late for deliberations, maybe we'll get an answer that they've chosen to stay late, but we'll see how they wrap it up. Jay Money says, great stream today. Thank you, Catnat Williams. Thank you right back. Thank you, thank you, thank you. Thank you so much for gifting the memberships earlier. Much appreciation for you. Thanks for hanging out. Let me scroll back a little bit of a ways. Let's see. Mary got here just in time for the Sean Grayson recap. So good to see you, Mary. Hope you're doing well. Speaking about the question on hung juries, if we pulled a random 12 from this chat in the Alicia Andrews trial, Betsy's like, I think we might have a hung jury. And that's the thing. Sometimes I thought cases would be hung and the jury comes back, and sometimes I think it'd be a verdict and the jury hangs. You just never know. You just never know. Let's see. Let's get to Sean Grayson. Okay, Trenton says from a different source covering this Sean Grayson case that Mary Beth Rogers, prosecutor, says she believes the instructions were included in error. The jury has clearly indicated that they are confused about the contradictions between the two. So 2 instructions seem to conflict. Let me search and see if we can... Was it instructions on... Let me just search Grayson. That might be too limiting of a term. Yeah, there's a lot of random. Let's do Sean Grayson. Let's do Sean Grayson. All right, I see Fox, Illinois has a tweet. They just say they're called back in. No context is given. Were you looking at an article, Trenton? It was... All right, thank you, Trenton. All right, so everyone, W's in the chat for Trenton getting us the other context. Let me pull it up for you guys. All right, so let me see if it's in this article. Because the link I clicked from you, Trenton, takes me to a Bing search result. It's acting weird. Maybe I can copy and paste it. There we go. That worked better. All right. Let's go to like 4:15. So this is where they enter back for jury questions. So 4:15 p.m. Shout out to Carly Bronkema. The courtroom was reopened and everyone was allowed back in. The judge told the court that the jury is asked to review several pieces of evidence. This is really tiny, sorry. Including body-worn camera, policies, and reports. The judge said the jury had a question about the jury instructions when it comes to convictions. Both sets of attorneys are discussing how to determine how this question will be answered. Court's on a break. We've got the defense said it would be improper to withdraw the instructions at this time. Sangamon County First Assistant State's Attorney Mary Beth Rogers says she believes the instructions were included in error as the sides determined what would be included. She said the jury has clearly indicated that they are confused about the contradictions between the 2 pieces of law. Judge Cadigan confirms that both instructions are directly from Illinois pattern jury instructions, meaning they can be legally used. Court is on another break so the judge can do more research. He's asked attorneys to write what they want to be shared to the jury. Court's back in session. The state has asked for one of the instructions to be withdrawn. If this happens, they would need to properly notify the jury and put the withdrawal on the record, the judge explained. So that update was um, about if this is her local time, I'm assuming this was 5:28 Eastern. That was like 23 minutes ago. So there we go. Thank you, thank you, thank you, Trenton. Thank you, thank you. And then yeah, I mean, and guys, I don't read into it one way or another that the jury's still deliberating, that the jury has questions. I like when juries have questions. And it means they're at least trying to get things correct and accurate and go through the motions, the instructions. Maybe I shouldn't say motions because that could sound like I'm talking about filings and motions. Uh, all right, and then they're back to deliberations. So I don't think we'll linger on for an update with that, but if there is a verdict, of course, I'll share it over on X. We'll talk about it tomorrow, and I'll throw up like a quick YouTube post or short video for a verdict over here. But been really interesting. As much as I wish there were cameras in more courtrooms, I still think it's interesting to consume a trial in the way that, we've really been relying on ABC 20 here. Every morning I'm resharing their first tweet. But if you guys use X, I know not everybody uses X. I think it's great. Show them some support. That support is a signal that this type of coverage is wanted. There's a demand for it. And it's really, really great considering we can't get a camera in the courtroom to have them giving like these play-by-plays. It reminds me, remember the Diddy trial? Oh my God, I should know his name. I read it like Inner City Press, right? Doing the play-by-plays. And it was so appreciated because that was federal trial, no cameras in the courtroom. So show them, show them the support, show them that, we appreciate the coverage. Let them know that it is something that we hope they continue to do in the future. But yeah, so we'll see. Yeah. 6205100. Love the name. So the jury realized it, but not all of the lawyers. That would be too much. It kind of reminds me of over in the YSL trial during the plea deal phase. We've talked about this a lot recently because of the work that Jim Robichaux and Tiffany Adams are doing for Antonio Sledge's appeal. The lawyers don't notice that there's an issue with the way they're trying to structure the plea agreement based on conflicting, and it would be in violation of the sentencing guidelines, the way they want to structure a plea deal. None of the lawyers notice it, and they already have the defendant say he knowingly and voluntarily signs this. But I don't see how it can be knowingly if it's legally void. So yeah, always funny when somebody besides the attorneys notice that something isn't working right. Okay, ABC has another. All right, we've got an instruction. Sweet, cool beans. Let me refresh over. Can I just click the last one, or do I have to like reload? Yeah, let's reload. Let's reload. Okay, so Cadigan re-enters. Judge Cadigan agrees with the state and the defense. He does not want to withdraw any instruction. He thinks sending a note to the jury stating, quote, "They are two separate instructions. The second page is not a continuation of the first page. We'll clarify for the jury." Interesting. I wonder, so maybe they didn't realize it would print that way. They never considered it would come off as confusing. And then the court goes into recess. We'll refresh that article quick to see if they give a different context or extra context. All right, and no update on that article. So that's the context we've got on the jury instruction, and now the jury's back deliberating. So huge shout out again to It's Trenton and for CMISH here, keeping us up to date with what's going on. Oh, okay, and CMISH's cameras are usually allowed in. Not sure why not in this case. I'm always for the cameras being let in the courtroom. I know that can sometimes lead to issues of sensitivity. I think the restriction on access to a public trial and also the defendant's right to a public trial. There's a public right, there's a defendant's right to have a public trial. I think the risk to any particular witness or a party to the case needs to be sufficient and extreme and severe to warrant a restriction on public access. So, because there certainly isn't a technology limit anymore. James Phipps says, after YSL and Karen Reed, the judiciary is afraid to let the public lift the rock and see all the creepy crawlies scatter in the sunlight. And for what it's worth, having a camera in a courtroom might make you a little nervous to do your job, but is that a bad thing? And it should work all ways, right? Some people get nervous on camera. Defendants, the public, the court of public opinion might sit there and watch someone's face on the screen. With the Alicia Andrews trial, the camera's like this on her face the whole time. And unfortunately, people are going to make comments about that. But does that outweigh the right for public access? I don't think so. I don't think the law thinks so. I don't think case law thinks so. So I would like to see that challenged more. I have one more closing thought, and we're going to wrap up. Andrea Burkhart, attorney, I'm an Andrea Burkhart stan. I don't stand for celebrities. I don't have fan clubs, but I really like attorney Andrea Burkhart. That's the closest I'll get to standing somebody. She's been commenting and covering what's going on with the accused shooter for the Charlie Kirk shooting, because there's issues of public access over in that trial. And she's been covering, and in her coverage, she's done these write-ups on her Substack that are bringing in all sorts of case law citations and other cases of interest where cameras in courtrooms, judges are shutting down camera access. It's just been, her writing is great, her legal analysis is great, and then her depth of I don't want to call it trivial knowledge, but trivia in the sense that these one-off little things that she can bring together. Just really, really awesome coverage. So let me get her Substack link if you guys are interested in public access, case law that relates to that. If you guys are interested in how that's playing out with not just the recent hearing for the accused, the Tyler Robinson, the Charlie Kirk accused shooter. She's also commented on Richard Delphi and Judge Gohl. She went in person to the trial because cameras were kicked out of the courtroom for that. So she went in person and covered that case. Let me share her X first. You'll just learn a ton from what she writes and what she covers. And then let me find her Substack. I'm not really that familiar with how Substack works. I'm usually clicking into the article directly. You can enter your email or you can hit no thanks, and then you can still move forward. So when you open this, you're going to see something like this. Don't think if you don't want to give your email, you don't have to. It'll let you know when someone publishes something new. But there is an option down here that says no thanks. You can click that and continue forward. So if you want to check this out, don't want to enter your email, hit that no thanks. That's my plug for Andrea Burkhart. Love her tons. You'll learn a ton. Robin Tylerson. No. Don't mess me up, Mavka. There we go. There we go. That's my wrap up, guys. 10 a.m. tomorrow. We'll get back together to continue with Alicia Andrews and any updates that come into play for the Sean Grayson trial. It is 6 p.m. on the dot. We'll see if Dolly has started his stream. We'll raid him back. He's covering, I think it was a short trial, like a 2-day trial that he was covering. I think another crazy neighbor trial. I forget the guy's name. But we'll redirect over there. Keep you guys trial watching. And it's 6, so I want to look, is Justice Serve TV also? I would imagine Justice Serve TV is talking about the update in the Sandra Birkmar case. Matthew Farwell has now been charged in relation to the death of an unborn child. So a lot of talk, speculation that now no longer seems like speculation, that Sandra Birchmore was pregnant when she died. It was treated at first like a suicide, and now it's not looking like a suicide, and Matthew Farwell might be in trouble 2 times with this extra charge there. And I don't know the ins and outs of that. I just remember the story from several months back, and I'm not surprised to hear this new charge being brought today, personally. The Justice Serve TV. All right, I think they're doing something about Alan Jackson. So I think, is Alan Jackson doing an interview with them today? All right, JSTV. It just says Alan Jackson in the thumbnail and title. I don't know if he's coming on to speak with them, but if that's the case, I'm sure a lot of you guys would be interested in checking that out. Love Justice Serve TV over there. They keep my iced coffee cold all day long, or soda sometimes, depending on what mood I'm in. We are going to get over to Dolly, though, who's already live. If YouTube wants to play nice. Talk. All right, it's Ohio versus Carl Klaus. So he's doing the rest of day 1. It's a short trial, and they are getting to verdict already. So quick one, if you want something to do, you can probably catch up on part 1 and then Dolly's part 2 today before the end of the night. So yeah, you mean pop, right? No. All right, guys. Putting on my walk-off music. We've had a lot of objections. We had some sustains today from the judge, so we're going to go back with our objection sustain song. You guys take care. Thank you so much for hanging out. See you guys all tomorrow.
Objection. You're ruining my case. State keeps spinning stories all over the place. From source to letters, they got no trace. Objection, you're ruining my case. Can't rule it out, rule it out. That's reasonable doubt, doubt. State says anything goes, spinning theories around. Can't rule it out. That's reasonable doubt. Letters on the table. Custody fights in July.